Hi, welcome to the Community Association Institute webinar for homeowners and board members on fiduciary duty. My name is Julie Cramer, and I am simply a homeowner in a community association. I bought my first condo in 1978, which introduced me to the world of association living and governance, operations, and management. I've been involved in this field ever since, serving in a wide range of volunteer positions, both locally and nationally. Currently, I serve on the board of CAI Illinois chapter, which is sponsoring this webinar. In 2015, I won a national award for the education of community association homeowners and board members. Education is my passion because I believe education promotes understanding, and understanding promotes community cooperation and civility. I've been involved in seminars such as this for 10, 12 years, but you'll have to bear with me a little bit today. It's the first one I've ever done virtually on a little computer. I'm used to being in a library room addressing a large group of people, so this is definitely a change for me. I want to introduce our panelists, Kara Cermak and Jim Arrigo, so you know a little bit about them. Kara is a former management company owner that joined the RealManage family 4 years ago. She has over 30 years of experience in the industry, managing communities and overseeing the day-to-day operations of a team. She served as a volunteer for CAI locally and nationally. She's been a member of the CAI faculty for more than 10 years, having earned the Educator of the Year award in 2017. She's now a member of the Community Manager Success Support Group for the RealManage family and teaches, mentors, and supports community managers and board members for their personal development. And I might add, she has a world of experience and expertise and insight into this industry. Jim is our attorney panelist, and he concentrates his practice in condominium and common interest community law and litigation. He works with association boards and their managers to recognize and address legal issues before they become problems. He drafts and amends governing documents and represents associations in all types of cases, including collecting assessments, rules and regulations, everything to appeals. Jim is a presenter at numerous association-related seminars, conferences, and in-house programs for clients, and has been author and contributor to association-related publications. So that's my little introduction. I'm going to turn it over to our panelists, and I think we are going to get started with Jim, who can give us a legal definition of fiduciary duty, which is of interest to all. Jim?
Thanks so much, Julie, for the introduction. Welcome to everybody who's watching. This presentation is about the fiduciary duty, which is one of the most important aspects of a board's performance of their duties on behalf of associations. Briefly, to define the fiduciary duty, this comes straight from the case law. Fiduciary relationship is one in which there is a special confidence in one who, in equity and good conscience, is bound to act in good faith and with due regard to the interests of the other. The short version of that means that you have what is probably the highest duty that can be found in the law to act on behalf of others. Corporations run by the fiduciary duty, financial services firms often run by them, and the idea here is that it's about the highest duty you can have. What is the nature of that duty? The fiduciary duty requires board members to act in a manner that's related to the exercise of the duty, and if they fail to do that, it may result in liability not only for the association but for the individual directors. The strict duties under the fiduciary responsibility are to treat unit owners with the utmost candor, rectitude, care, loyalty, and good faith, and in fact to treat them as well as the board member would treat themselves. That also applies to dealing with association finances, where this fiduciary duty requires the board members to treat association funds and manage association funds as if they were their own and apply the same duty of care to it. There are some provisions that we'll talk about as we go a little further along that deal with how board members satisfy these duties and what some of the requirements are. One you'll hear about is called the business judgment rule, and it is one of the most important aspects of applying the fiduciary responsibility to your day-to-day work on behalf of associations. But we'll get into that a little more as we go forward. We'll also get a little more into who the duty applies to specifically, what the risks are if you violate the duty, and some steps that you can take to help satisfy the duty. And in large measure, what boards do to satisfy the duty, especially those boards that have management, is working closely with your managers who work with the attorneys and have a large breadth of experience in dealing with these issues. And to talk about that for a minute, I'd like to bring on Kara.
Hi, everyone. So fiduciary duty in terms of management, one of the biggest recommendations that I have in order to be sure that you are maintaining your fiduciary duty is to establish norms for the group. So when we don't allow particular behavior, then we run less risk of having a problem, even as a board of directors or even as an individual board member. So one of the things that I really do recommend is establishing norms. So what does that mean? Don't personally attack one another, or asking questions of management so that you, when you're making a decision, you actually understand what it is you're making the decision about. Because one of the things that I think, well, that I know is that boards don't understand that they are ultimately responsible for the information that is provided by management. We're carrying out the day-to-day operations on your behalf and on the community's behalf, but these are decisions and processes that you have put in place as boards. So if you say to yourself, I didn't put any process in place, it's a place to ask questions. One of the things I want you all to know is that there is a very big difference between asking questions and micromanagement. Micromanagement has an actual definition, okay? And you hear people bat around fiduciary duty and micromanagement, and the definitions aren't even close to what they actually are. So what micromanagement means, and it can be a problem for even maintaining your fiduciary duty, because, by the way, we have a skill set. This is actually something that is our career, and we, by and large, know what we're doing. So when you are bristling against our recommendations to the point where you go all the way to the other side because you know better, you might not know better. So questions are, please ask us questions. I promise that we want to ask or answer your questions. One of the things that I have included in the handout that you'll get later on is a potential code of conduct that really regulates what you're doing as a board of directors, both within the board meetings and without. One of the things we'll be talking about is that rogue board member that is out there giving direction to contractors that has not been agreed upon by the board of directors. That is a big problem. And it's a big problem, not just, you could get sued, or when you get sued, if you are in violation of your fiduciary duty, you're actually exposing yourself to potential personal liability. So we need to be sure that we're all adhering to what it means to be a board of directors, and remembering that you are actually maintaining not just a neighborhood, not just, your community, but you are also maintaining a corporation. And that is something that we all need to keep in mind. So I know Jim has some more to add to that, and I will be back after that.
Just touch briefly on what Kara mentioned about the risk issue. A lot of boards I talk to say, well, we have D&O coverage, directors and officers coverage, so that should take care of it. If you read the language of most insurance policies, probably not all, but most insurance policies, they say that they'll give you a defense and indemnify right up to the point where it's established that a director or officer acted in a way that, and the language they use won't say fiduciary duty, but it will reach right out and grab the essence of what fiduciary duty means. What that says is that if you breach your fiduciary duty, at the end of the day, your insurance isn't going to cover it. That's going to come out of your assets, your home, your car, your accounts. So it's really important to understand that the stakes for fiduciaries are fairly high, and that's why it's really important that board members pay attention to this and cover their bases on fiduciary responsibility. Kara raised some great points about micromanaging and also asking managers for information, and we'll talk about the information issue a little later. I wanted to raise an issue now. One of the questions that I get a lot is who is subject to the duty? Is it the board as a whole, or is it the individual directors? Section 18.4 of the Condo Act states, and quoting, in the performance of their duties, the officers and members of the board, whether appointed by the developer or elected by the unit owners, shall exercise the care required of a fiduciary of the unit owners. That's quite clear. It's not the board as a whole. It's the individuals who make up that board who have the fiduciary responsibility. In practice, this means to an extent that board members have to pay attention to what the other members of the board are doing. Say, for the sake of argument, records aren't being maintained, and it's the secretary's obligation to maintain those records. If other board members learn about that, to satisfy their fiduciary obligation, they have a responsibility to take action, to do something. It could be as simple as talking to the secretary and making sure that there are standards for the maintenance of records. But if it becomes more serious, the board may have to take more serious action as well. Similarly, with the maintenance of the association's books and records of account, if the treasurer is not keeping records on time and up to date, the board as a whole, not the board as a whole, the individual board members who make up the board as a whole, each have a responsibility to make sure that responsibility of the association is fully carried out. And again, your manager is often a starting point for dealing with those problems, because they're often keeping, tracking and storing financial records for the association and providing them to the board member who's responsible for generating the reports. Kara can probably talk more about that than I can.
Yeah. Julie, did you have something?
Well, I wanted to ask, we often hear, from board members, that's why we have a professional management company. So I was hoping that you could address that from a manager's standpoint.
Right.
Because that's, sometimes boards will say that's why we have it, so we don't have to do it.
Okay, exactly. So what you're doing essentially is delegating things to a management company. And of course, as I said, we have a skill set. So it's a great idea to delegate those duties to professional management. Now, if you don't have professional management, you are actually maintaining these records yourself. But if you do, what that means is maintaining the records as the secretary or the treasurer simply means that you know what the document retention is. You as a board and as individuals know what's within the financials. And by the way, no one expects you to join the board and be a CPA if you want to be the treasurer. It really isn't that difficult to actually take a look at a set of financial statements and learn the story about that community rather quickly. So if you say to yourself, no, that's not how I feel about it, I couldn't tell you a story about my community, well, that's a place to ask questions. Even as simple as explain the format to me, explain what the attachments mean. And very often you'll hear from board members, this is 100 pages of stuff. Well, they're supporting documentation. The general ledger detail is supporting documentation for the financial statements themselves. If you don't want to look at all those specifics, that's understandable, by the way, because not many people want to look at the general ledger detail. But if you have a question in looking at the financial statements, that's a place to look. So it's super important that you understand that, just because it says secretary is maintaining the records, treasurer is maintaining the financials and the payables and all that, we know very often you're not sitting there maintaining them yourself, but you need to be sure that your management company is maintaining them. So just asking a question, what's your record retention policy? And adopting it as a board of directors. As I said, establishing norms for perhaps a conversation that the treasurer intends to have once a month, and then the treasurer might want to present the information at a board meeting. So it's a delegation of responsibilities, but it does not remove your responsibility to actually know the information to whatever degree you are comfortable knowing that information. As a group, you're individually responsible for the fiduciary duty, but as a group is where you establish norms and be sure that you know exactly what's going on.
Mm-hmm. And as Kara mentioned, there are some associations we're sure out there who don't have management at all, and then it's a little more direct. Your contact with those subjects is a little more direct. Unfortunately, the necessity that you inform yourself of how those things like the keeping of the books and records and the record retention works falls a little more directly on board members for associations that don't have management. But as Kara also said, your managers probably have that information. All you need to do is ask where it is and satisfy yourself as a board member that, in fact, what needs to be kept is being kept. You may only need the information that's on the bottom line, but to know that supporting information is there is something that would probably, should probably give a board member a fair amount of comfort with dealing with those records. I want to talk for a second another issue that comes up a lot that relates to boards and management is the handling of association confidential information. So what is confidential information as it relates to an association? It could be financial information. For example, the ledgers of account for each and every owner of a unit in the association is probably in the books and records of the association. So you could go in at any given time and look up what John Jones in Unit 100, what his assessment balance looks like, whether he's been paying on time. That information is there because it has to be there. It's stuff that the association needs to have access to as fiduciaries. But that very individualized information is also confidential for the association. If you look at Section 19 of the Condo Act, which relates to the production of records upon request, there are specific sections in there that limit someone making a request, a member of an association making a request, that prohibits them from getting information that relates to any other unit owner except themselves, unless there's a court order that requires it. That's because that information is confidential. Similarly, boards talk to their attorneys, often through management, but boards talk to their attorneys. And those communications are also cloaked in what's called the attorney-client privilege, which really becomes important if you're ever in court. But it still is a protection against the disclosure to the world of the advice that your attorney is giving you and the information your attorney is giving you. And a question that comes up broadly, and I'm sure Carol, she's chomping at the bit to get to this one. One of the issues that comes up a lot is that an individual board member, they may have an issue that's personal to them. They may have an axe to grind. They may disagree with the majority, and they want to communicate out to the members of the association information that they've learned through the attorney or through the records of the association that may be helpful to the position they want to advocate for, but they're confidential information. So how does that confidential information actually get released consistent with the fiduciary obligation? It gets released only if the board votes to release it. If an individual director releases attorney-client communications for the sake of argument without the board's okay, and he has breached his duties to the association and potentially could be subject to liability, especially if that breach comes back to bite the association in, for example, subsequent litigation. So, and I said, I know Carol was wanting to talk about this one. It's real important that boards pay attention to maintaining the confidentiality of their records and maintaining tight controls on the release of confidential information. Kara?
Yeah. One of the really important things is that you are being provided information about a corporation. If you are discussing litigation as an example, there is actually a story that through CAI, it's many, many moons ago, but what the story is that there was litigation. It was discussed in an executive session and they had planned on going, here's what our strategy is. And there was a board member discussing that strategy with his wife at a restaurant. And as luck would have it, their server was related to the person having to do with the litigation. So needless to say, that didn't work out very well because that's, strategy and your responses and all of your documentation, having that released is not good for litigation. So it's very important that you understand that, quite frankly, you shouldn't even be sharing private information with your spouse or your significant other. You can obviously talk to them about general things that anybody would know if they sat at the open board meeting. But imagine If your spouse likes to talk to all the neighbors and they have, their little coffee twice a week, it's going to get out. That information is going to get out. So you absolutely need to be very careful. And the other thing I wanted to say is this: you go to an attorney like Jim, who really knows what he's doing, and it's a very difficult subject, and you get his recommendation not only verbally, but it's such an important issue that you get it in writing. Okay, none of this. It's too expensive. I don't want to pay for it in writing. Bad idea. But you get all these experts that give you advice: your management, your attorney, an engineer, your CPA, and then the board says, nope, I know better than that, and we're going to go this way. That's not a good idea, because naturally you've just gotten all this advice from the experts, and for you to go in a different direction, there might be times where that happens, but you better be super careful to have all of that supporting documentation and to have a discussion with your attorney. That's what we're here for, we have expertise that most of you don't have, which is okay, because I probably couldn't come do what you do for a living either. So, Jim?
Well, and Kara was talking about the issue of, sorry, I lost my train of thought. The short version is things like bids and proposals that are written information of the association. That should be kept confidential. One of the reasons you get a written opinion from your attorney on things is so that goes in the files of the association, not so that it can be handed out, but so that it can be relied on by the members of the association, and that if, God forbid, there is litigation involved there, the association's board, if they've acted as their attorneys have advised, can point to that. That's an issue that is at the heart of the business judgment rule that we'll talk about in just a little bit. But the issue of relying on experts is crucial to protecting you as board members. And I'm noticing, I'm seeing as we're going along, some questions are coming in. So there are already some questions teed up for later on. The question is whether we want to address those as we go along, Kara, or press through and cover a couple more issues.
Yeah, Jim, I actually have a question related to this that I'm hoping that you two can shed some light on. It's more of a practical question, and that is, I think boards are, for the most part, very aware of their duty of confidentiality, but sometimes it goes so far that it's difficult, like for in the minutes. And let me give you an example. Whenever there's, a violation and you have a closed board meeting and you discuss it and then you come out to make your vote. Can you give us a little more guidance as to exactly how the minutes can officially read? Because the example I'm thinking of is it was not a serious issue, but it was a constant violation of storing things in the parking space. And so at one time we wanted to say, gee, did we find that person before for this? But when we looked in the minutes, because everyone is so scared to put anything in the minutes, we couldn't tell if we actually find, because we weren't sure when we found different votes for violation finding, what units they went to and what they were for.
Well, let me address that, and some of this is going to fall into Kara's bailiwick as well. And so that you know, and Julie, you may know, year before last, I was on the panel for the CAI legal session, and one of the issues that I talked about was the issue of closed session meetings and how boards can keep minutes that are compliant with the law yet don't reveal too much information. So I talked about that. And to answer your question here, and by the way, I didn't mention before, I was focusing on the Condo Act, but the courts have applied the same fiduciary standard that applies to condo boards to non-condo association boards, whether you're subject to the Common Interest Community Association Act or SECA or not. If you're a board member, you're subject to that duty, whether it's condo or non-condo. A short answer is that under the statutes, boards can meet for 6 separate reasons outside the presence of the members. Those reasons are to discuss or consult with their attorney on issues that relate to litigation that's pending or contemplated, for issues that relate to individual violations, for issues that relate to collections, to address and discuss contracts or contractors and proposals for same, and to discuss employees of the association and their issues as well. So those 6 things, the board can meet in closed session without the members present and discuss those things, but they can't vote there. To vote on any of those things, they can only vote in a meeting that's been subject to at least 48 hours notice and is held in a situation that's open to the members to attend. So how do you do that? The nuts and bolts version is that the members of the board are free to keep their own notes of closed session meetings. Their notes of closed session meetings are not the minutes. So they're not discoverable. So they might be discoverable in litigation, but they're not producible upon the request of members of the association. So that's where a connection can be made between what specific issue or owner you were talking about in the closed session and how that translates to what got done in the meeting. And my recommendation for doing that is, as you go through, let's say you've got 2 violations in a collection matter. You call the first violation matter A, and you refer to it as matter A. When you go into open session on matter A, as discussed in closed session, there's a recommendation that the board vote to approve the imposition of a fine as discussed in the closed session. All in favor. You go through your procedure and you get the motion, the second, and the vote. So the vote can be tied to what you understood to have happened in the closed session, but you're still not divulging the confidential information about that owner. The same applies to other violations and collection matters that are discussed in closed session, but the votes for which have to be done in the open session. Does that make sense?
Yes, except for if you look backwards at those minutes at a later point in time, nobody knows what matter A was.
That's true, and that's one pitfall of doing it that way, but it protects the confidential information of the association, because minutes can be requested at any time by any member of the association dating back at least 7 years. So the confidential information of members of the association needs to be protected. The way to do that is for the board members themselves to keep, and feel free to pass on or give to management to keep, notes of those meetings. Sometimes managers will sit in on the meeting and they may have an agenda. The managers may be preparing the packets. In fact, usually do prepare the packets. And Carrie, you can talk about this in a second. The board packet that the board members get before the meeting should probably have these matters in there, and they can go ahead and set them up on the kind of code that I was talking about. So the board members get their packet, which is not subject to being delivered to the members, and they know what those matters are. And so management keeps a copy of the board packet. You can easily go back, cross-reference the 2 things, and figure out what was being discussed. Okay,
thanks. Time is really funny. We're halfway through our session here. Can I maybe? Oh, I'm sorry.
Can Kara pitch in on that information for a second on the maintenance of those records?
Yeah, just really quickly. My recommendation is that you actually have someone that is skilled at taking minutes, take your minutes. Even if that's recording it and giving it to a recording secretary, then you don't have to worry about all of this. Secondly, we talked about records retention and those things. All of those questions that you were talking about, Julie, I would have in my board packet. So if you have appropriate records retention, even if it's not a formal packet, as long as you know what you voted on, because I would imagine that, hey, we have this violation and it's at this address, and really all you're doing is saying matter A in the actual minutes. But you should have supporting documentation, and that speaks to records retention.
Right. Okay, very good. Okay, let me get to some of these questions because it is a Q&A session and we want everybody to be able to get answers. So answer the question, but try and keep them short to the point. Maybe Kara can address this because you deal with new boards all the time, coming and going, new members, elections, whatever. And so those new members, although they're brand new board members, they don't have the benefit of all this knowledge. So what's the reason? The question is, what is a reasonable learning curve for a new board member in a very challenging community?
So I would tell you that most communities have challenges. And what you're doing is bringing together people that are essentially strangers and all have a different skill set. And what you want to do is operate as a team, not just the board of directors, but all of your professionals are a team with you, which includes, quite frankly, your contractors. If you have a team approach, that's going to serve the greater good. In terms of, how quickly someone might learn, I think it really depends on the person. What you want to be sure is that you give them some, documentation for the last few months, give them the minutes, have some type of orientation and discussion. And then what you're going to find is some people are very comfortable speaking up right away and some people are not. And that's okay. Either way is okay.
With regard to learning curves also, it's important to understand that as soon as you're on the board, you're a fiduciary. So that duty isn't particularly forgiving when it comes to that. What I do with regard to boards is I have materials, a primer for board members that I prepared that has background information on a lot of these issues, explanation of the duty and explanation of what it means and how you can satisfy it. And I make sure that board members who are new and newly elected get that right off the bat, the first opportunity. I send it on to them to read and then respond to any questions, ask them to put together any questions they have and get those forwarded on through management, if there is a management. Because unfortunately, ignorance of the fiduciary duty or violation of the fiduciary duty through lack of experience isn't, at the end of the day, going to excuse the conduct if the situation becomes, for example, subject to litigation.
Okay, very good. Another question, if homeowners are entitled to view signed contracts, should they be posted or should the onus be on the homeowner to request them?
I'm all in favor of communicating often with the homeowners, communicating challenges and problems as well as successes. Okay. But do I think we should be throwing out every contract for everybody to see? I just think you're getting into nitty-gritty details that they can't possibly know if they're not at your open board meetings and listening to the discussion. So I personally would put that onus on the owner. Very specifically about contracts, there are things that I do not think you should put on the onus in terms of communication on the owner. But as it relates to signed contracts, I would ask that they request it.
I agree with that. Normally, I don't recommend that associations post all their contracts, and there are a lot of practical reasons, some of which deal with the competitive terms that a contractor may provide your association. And yes, if someone specifically requests an opportunity to review that contract, they have the right to do so. But bear in mind also, like for big projects like roofing projects or exterior maintenance projects, oftentimes those are contracts that run into the hundreds of pages.
Right.
A lot of major contractors use what's called AIA, which is the American Institute of Architects, form contracts that they have. And these things, like I say, can be hundreds of pages long. You don't post those because AIA is very strict about the copyrights on their forms, and you don't want those to be on your website. If someone expressly requests those, remember that the statute, Section 19 and Section 1-35 of the Common Interest Community Association Act, don't directly require that you give people copies of documents. You only need to make the association's official copy of those documents available for inspection or examination, and potentially for copying. So that's one way to get around that and address that issue. And I don't want to get too far afield before I talk a little bit about what the business judgment rule is. And I know we've got more questions teed up, but one of the things I wanted to talk about is the business judgment rule and what it is and how it applies. There is a presumption in the law that directors are satisfying their obligations as fiduciaries, unless there's evidence of bad faith, fraud, illegality, or gross overreaching. And courts don't typically interfere with association board members in the day-to-day conduct of their activity. But there's an important caveat here. In order to satisfy those requirements, that you're doing your duty according to the fiduciary responsibility, board members are obligated to become properly informed on the issues that they're facing. Oftentimes that requires that your board consult with qualified professionals. On legal matters, that's easy. It's someone like me, an attorney for the association. And if your association doesn't have an attorney who's regularly working with you, you should probably establish a relationship with someone that you can call if you have legal questions. And the same applies to issues like roofing and maintenance and water leaks and landscaping and a lot of different things you deal with. I don't expect board members to be expert in those areas, and board members shouldn't hold themselves out to be experts in those areas. Instead,
Yes.
you ask the question from someone who is an expert in that area, get their information, get their recommendations, and then, and here's an important part, rely on it. A lot of people probably have heard of the Palm 2 case. In the Palm 2 case, an issue of business judgment came up, and it was a question of what the attorney advised the association. And there was information in the court's file that indicated, evidence in the court's file that indicated what the attorney advised the association to do with regard to certain specific issues. But there was nothing in the file that indicated that the association took that advice, that they relied upon that advice and acted accordingly. It's a really good idea to make sure your records reflect that obtained attorney opinion, obtained contractor opinion, followed recommendations, that you make a notation that you did that so that you can establish later on that you not only informed yourself, but that the decision was based upon the information you received rather than based upon lay information from people who might have a very strong opinion, but not a lot of technical information.
Absolutely. 100%.
Yeah. So I wanted to hit that because it's a really important aspect of the fiduciary duty that board members understand. And again, this is one of the things that I always recommend you work with your managers on, finding people who can give you the information you need to make an informed decision. All right. Enough on my soapbox on that, but happy to go back to some more questions.
Thanks. There's a number of questions that relate to the records and changing management companies. So here's a question. What happens if we switch over management companies, and how is that information transitioned? So
I'm going to let Kara answer that.
But how is that transitioned?
So most of the professional management companies, we all know each other. We have no desire to make life difficult for the next management company. It's just an unwritten rule that we help one another when there is a transition. So the biggest thing is 9 times out of 10, let us just handle it between the two management companies, because it gets very difficult when you have like 5 people saying, I want this, make sure you do this. So if you have records retention policies, specifically, I recommend, and I'm sure Jim does as well, having it in your management contract to say, here's what happens if we transition. What you're going to find is, especially now, we don't have to give them usually 50 boxes. We can actually send them the information electronically. So just know what the two of them are doing, the two management companies. You can ask questions about that. And then you can, at a board meeting, you can actually say, well, I'd prefer this, or I'd love to see this. But generally, it's not a problem.
Okay. Very good. We have a 5-member board. 3 of the 5 voted to allow the 3 officers to make decisions outside of board meetings. What is the point of having a board?
Let me answer that. First off,
that's yours, Jim.
You betcha. First question, and it's kind of a question back. It's not really a question. I assume when we talk about officers that every officer is already a member of the board, because in a condominium or a community association, The officers are selected from among the members of the board. You don't have 5 directors and then separate people who serve as officers. The treasurer is one of the board members, so they're subject to the duty. The secretary is one of the board members. So I'm going to presume for the purpose of the question that's the situation. But if you've got, for example, 3 board members, a majority of the board, who voted to allow an individual officer to make decisions, short answer is you can't do that. Because the law requires that the board make decisions. And the law requires that those decisions be made in meetings open to the members to attend. The board cannot legally delegate authority that the law provides the board members are responsible for. So any action by a majority of the board to delegate its authority to an individual is null and void in my view. And if the board is acting on that and allowing individual board members to take action on behalf of the association, remember what I talked about before? When you find out, for example, that someone's not satisfying their duty, the rest of the board members, as soon as they find out about it, have an obligation to correct it. And this is a situation where the association has an obligation to correct it. If there's any doubt about these issues, this is a situation where the association probably ought to reach out to its own attorney and get information, guidance, and direction on how to address that issue.
And I will tell you, from a management perspective, there are nuances to this. And that's all the more reason to talk to your attorney so you 100% understand exactly what is supposed to happen. And the other thing I want to point out is that I think it was Palm that said discussion is supposed to be done at the open board meeting. So the owners don't just have the right to hear what you decided, they also have the right to hear what discussion takes place. Now, does that mean, you need to sit there for an hour on every decision? No, it doesn't. But they need to hear the thought process as well.
Yeah, that's a good point. Here's something that's related. Can a board have a meeting that's not really a meeting because there are no votes taken? And if so, can they take a straw vote to get opinions?
Okay. Short answer is if a quorum of the board is meeting, for example, in the last question, there were 5 board members. I'm going to presume that your instruments provide that a majority of the board, or 3, is a quorum. If a quorum of the board meets, congratulations, you've held a board meeting. So the statutes apply in every event. The only things you can discuss in a board meeting that is not open to the member are the 6 things I identified before. And that's found in Section 18A9, capital A of the Condominium Property Act. There's a listing of the 6 things that board members can discuss but not decide on in a closed session. Generally, however, contracting issues, what a proposal is going to look like, what work needs to be done, those are discussion matters that should take place in an open meeting. It's only when you get down to the issue of discussing engagement or dismissal of a specific independent contractor or employee, those discussions can take place in the closed meeting, but the votes still have to take place in the open meeting. So,
I will say.
Go ahead. Yeah.
I'm sorry if I'm interrupting.
Absolutely.
So I saw, Brandon, that you just said, hey, it seems like they're having questions about a town hall type meeting. I love town hall meetings. I love them because board members are representing the owners. So the owners should be able to communicate with you on matters that, they want to be heard about. So town hall style meetings, I love them. Maybe Jim, you can talk quickly about what the framework so it could be legally done.
Right. Well, and so here's a couple of somewhat competing issues. For a regular meeting of the board, where the board is doing the business of the association, typically pursuant to an agenda and notice and everything else, and you've got a specific laundry list of things that the board has to deal with. They have to approve their financials. They have to, work on a budget. They have to deal with the violation issues that have been discussed in closed session. Those meetings should be set aside for the business of the board. And it shouldn't necessarily be a situation where members of the association can interrupt the business of the board as it's being done. I'm fine with, and I always recommend that the association have a question session, typically at the end, but I don't normally recommend that the board engage in answering those questions at that particular session, which is different from a town hall. Oftentimes people will ask the question, well, what about this maintenance issue? And the board's going to need to go back, talk with management, look into the situation, and figure out what is going on so that they can come back later and intelligently discuss that with the members of the association, and that's fine. A town hall, on the other hand, to me is a situation where it's more like a listening session for the board, where it's open, the floor is opened up. There isn't any official business for the board to do other than convene and close the meeting.
And but listen.
The purpose there is to listen to the questions and concerns that the members have to raise. Some of those questions and concerns are likely to find their way onto subsequent agendas as issues that the board's going to address. But I recommend that for a town hall, there not be an expectation that the board's going to respond to these points in real time.
Right, absolutely.
The board has to go back and discuss.
Right.
So Jim, if we would have a meeting just with the owners to have a conversation, similar to how you might do in a hallway, but with the entire group or whoever wants to attend. Not really board business, just to have communication. How would that be noticed if it's not an annual meeting? There's no voting. It's just a get together. I'm going back a lot of years, but before Palm, we would just very impromptu, like meet in the garage, or we'd have, bring some food and everybody would talk. But because of all the legalities that have come up over the years, I think communication has really suffered. A good way is to do newsletters, but that also takes work and time, and not every association has a volunteer who is willing to do a newsletter.
Well, and from my perspective, that goes right to the heart of the issue, the difference between a meeting and a town hall, where really what you're doing is listening.
Okay.
And I want to also point out that a lot of associations confuse members' meetings and board meetings.
Yes.
At a board meeting, the members really don't have a role. The board, they're there to observe the board doing the association's business, essentially as if you're watching a television. At a members' meeting, the board has no authority to do any of its business there. Oftentimes, the board's president acts as the presiding officer over the meeting to make sure that the procedural formalities are followed, but the board doesn't get to decide anything. If there are matters that are on the floor, they're for the members to vote on. If there's, for example, an election, that's for the members to vote on. And the board members are members of the association. They can cast their ballots too. But it's important to keep those two kinds of meetings separate. And if it's just going to be a discussion, I'd prefer, if it were me, to call it a town hall or an informational discussion session and indicate on the notice, and you're free to send a notice out. It can be 24, it can be 48 hours, it can be 10 days, it can be whatever, because you're not conducting board business. But it should note on that notice, this is not a board meeting at which association business will be conducted.
That's interesting. That's something that I've really missed over the years, and I'm glad to hear that we can do that.
Kara, I know you have something to say on this.
The things I have to say are this. Remember, when you do that, obviously you got to listen. They call it a hearing because you got to listen. As an example, violation hearing, listen. Remember to embrace different opinions, to actually listen to the owners instead of potentially taking offense to what they're saying. Rather, listen to what they're saying and then, get notes. And then the board can discuss it at an open board meeting. It's really a wonderful thing because communities are a microcosm of society. When we elect representatives for us, we don't get to, other than give them our opinion, we don't get to decide anymore. So it's not like this is a unique concept. It's just that people think, oh, it's my home, so I get I get to give an opinion and make decisions all the time, but it's representative government.
Mhm.
Yeah, and understand also that the fiduciary duty obligates the board members to act on behalf of and in the best interest of the members of the association. Sure, there can be differences of opinion as to what that best course is, and if the association is getting professional consultations, it may have information the members don't, that in some cases, unfortunately, you're not free to share. But it's also important to listen to what's important to the members of the association, because the board shouldn't be essentially acting as a despot over a kingdom. They are elected officials, and if the sense of the membership of the association is in a different direction from what the board's predisposed preferences might be, then I think the board has at least an obligation to listen to those and consider directions that may be different from what they were planning on.
Okay. Here's one. Who would call a members meeting? We have monthly board meetings in which we have board business and also a homeowner forum, which tends to run very, very long. So I think this is a good place for you, Jim, to explain about watching the television.
Right. It's really important at a board meeting to let your board do the business of the association, make the decisions that need to be made, approve the financials and approve the contracts and take the steps that need to be made without interference from the members of the association. Oftentimes, the forum portion of a meeting, a lot of associations call it a homeowners forum, and it's really a what I talked about before, allowing members to raise issues and questions. I think it's important for the board to let the members know that they shouldn't expect an answer today, but that the board will take note their concerns and take under advisement for potential future action. But with regard to the conduct of the business of the association, they should treat it like watching a TV. The other question here is the first part of the question was, how does a members meeting get called? Your instruments, your governing instruments, declaration and bylaws, typically in the bylaws, will specify how those things happen. If you're a condominium association, your bylaws are subject by law to what's in Section 18 of the Condominium Property Act, which specifies how those things work for condominiums. So even if your own instruments may be different, Section 18 applies. If you're a non-condo association, again, the first place to go is look at your bylaws and see what those bylaws say about how meetings get called. Typically, the president or a majority of the board can call a meeting of the membership. Typically, the notice is 10 to 30 days, except for budgets where it's a little different. And in many cases in associations, the membership can call a meeting too. How does that work? Under the Condo Act and under the Common Interest Community Association Act, no fewer than 20% of the owners, it's by percentage in a condo, it's by numbers in the HOA, they have to submit a petition to the board to call a meeting. Once that petition, signed by the appropriate number of people, is submitted to the board really has no choice but to call a meeting notice up and call a meeting within 30 days. And that's mechanically how it works.
I will say there are tips and tricks to homeowner forum not going forever, because that is not sustainable. So one of the things I have done with communities where this is an issue is I actually have rules of the road for this meeting, and I'll hand them out to any of the audience members as they arrive, and just say, here's how this is going to go. So we're going to have audience participation. It's going to be 15 minutes. Each one of you is going to have a little bit of time. This is not the time for debate, because we need to do some research on your questions, but we do want to hear from you. And then you have to enforce it. I know it's a pain and people get mad about it, but it has to be enforced. Otherwise, you're just sitting there fighting with each other at every board meeting, and that's no fun.
Yeah. Yep. And Kara, I also wanted to say that boards should encourage the homeowners to communicate with the management company outside of these board meetings. I can't tell you how many believe that they have to come to the board meeting to, I don't say file a complaint, but to tell them something. So we'll have a homeowner come and they will say, well, my roof is leaking, or this is leaking. And the homeowner forum is not the place for that. And we try and educate them that as soon as something like that happens, call the management company. Don't wait for a board meeting.
Right. And if you're seeing that happen more often in any particular community or individual communities, then you have a place for communication. You have something to teach the owners, and that's what I would do. And I get it. Newsletters take a lot of work. It doesn't have to be a newsletter. It can be a quick communication to the owners about a specific subject, which doesn't take that long to put together.
Right. Right. Yeah. There was one other one here that I was asking. Oh, should meeting agendas be posted for board of directors meetings?
There isn't a hard and fast rule on that. I always think it's a good idea. The reason why, or include at least a thumbnail agenda of the business that's going to be discussed in the notice of the meeting that goes out. The reason why, because we all know that everybody's busy. A member of the association may have issues they really care about, and they want to know when those issues are going to come up before the board for discussion. And if there's at least a rough agenda that's included with the notice, they can make an educated decision about whether they want to invest the time to come to that particular meeting versus a different one where issues they don't care about are being discussed. I think it's a good idea. It's not mandatory.
Yeah, it's not mandatory. And to be honest with you, I didn't do it all that often. What I would rather do is communicate with the owners and say, hey, we're going to be discussing and deciding upon the landscape contract next month, or here's our calendar of events in terms of discussion on large items. I just feel like agendas are so not, they just don't provide you enough information. I'd rather give them sentences,
Right, because oftentimes an agenda will look as simple as old business, new business, and they don't provide detail.
Right. Yeah. Right. They don't provide any information. Yeah. Let's see what else we have here. This is very little print, and so you can pardon me if I am squinting on this. Same thing. Want to know if an agenda should be posted before our board of directors meetings. Yep. You already answered that. Let's see, what other ones do we have here? I can't see any. Oh, one had a question on board member boundaries. It says, as a volunteer and as a fiduciary, we are also members and homeowners too. So
that's a little open-ended, but it tracks with concerns and issues that I've seen raised a whole lot. For example, board members are members of the association. On the one hand, they get together and they meet in front of the members of the association to do the board's business. On the other hand, they, to an extent, have a right to lead their private lives and shouldn't necessarily be subject to being buttonholed in every time they walk down the hallway or every time they go anywhere and being say, well, what about this? What about this? That's the kind of situation where a board member has to use a certain degree of decorum and say, hey, you know what? I'm on personal time right now. Can you do me a favor and put your concerns down in writing and forward them to management so that they can forward them onto the board in the packet so we can consider that issue is a way to do it. Obviously, if it's an emergency, absolutely bring it up to the first board member you see.
Mm-hmm. When you're in the meetings themselves, I have a community that when board members have a specific issue with their own home, because that question was kind of open-ended, they make them put themselves on the agenda just like any other homeowner so that they aren't personalizing decisions that are made during the meeting. So that's a good recommendation.
Mm-hmm. And in that situation, the board member isn't necessarily forbidden from voting on the matter when it comes up before the board.
Right.
That distinction between a true conflict of interest and a fiduciary responsibility. As a member of the board, if it's a maintenance issue, they have the same interest as the other board members in seeing that maintenance issues get addressed. If, on the other hand, they're looking to move themselves to the head of the line to get their maintenance done before the other things that have been scheduled of a similar nature, that probably goes the other way and looks more like a conflict of interest. and an abuse of the board authority.
Right.
Great. Here's another one. The association governing documents allow for board committees. Can the board create a board committee with the authority to review and approve compliant homeowner architectural variances?
This goes to something that isn't found in the Condo Act and it isn't found in SECA. It's found in another statute, Illinois statute, that you're probably subject to. I will start with the presumption that most associations, not all, but most associations are not-for-profit corporations. And there's another statute out there called the Illinois General Not-for-Profit Corporations Act. And it has some provisions, amazingly enough, that deal with residential associations. There's a long history behind how that happened, but take my word for it, they are. And that statute has a definition of what's called a committee and a commission, and they're not the same. A committee is any group that exercises any of the authority of the board. For example, if you have an architectural review committee and those requests for architectural approval come into that committee, and that committee, under your governing documents, has the authority to make a decision, then it's a committee, and it has to have no fewer than 2 board members on it, and no fewer than a majority of its members need to be board members, if it's going to wield the authority of the board. On the other hand, if it just hears these applications for work, evaluates them, maybe asks questions, gathers more information, and then makes a recommendation to the board, and the board as a whole, at a meeting, makes the final decisions, then it's a commission. And there's no real requirement for who can be on it. Anyone in the association can be on a commission because all they're doing is making recommendations, the board's making the actual decisions. Hope that answers that question.
Okay. Very good.
Sorry, Kara, I didn't mean to step on you, but that's technical.
Good job.
All right. Well, we're up to 2:00. We usually budget for about an hour, but we certainly will go longer if there's any other questions. So if you have questions, put them in the chat now. And
I have, just while people might be asking questions.
Yeah, please.
One of the things I want you all to remember is that it's representative government. And by the way, if you're representing your community association in an angry and icky way, guess what? That's what's going to happen. People are going to communicate with you in the way that you lead. Do as I say, not as I do, right? So 2 really important things. You want to be sure you remain objective, even in the face of something that just doesn't make any sense to you. You want to hear people out, and you want to do the best you can to understand that you come to the table with preconceived notions, and you want to try to recognize them and then push them to the side for a moment. The other thing I recommend is that you should be proud. Be proud of your community. Be proud that you're a volunteer. People will see that authenticity. They will see that you're proud to represent the community, and your communications will go entirely differently. No question about it.
That's the beautiful, optimistic thing about managers. They see all this stuff on a day-to-day basis, and they can make great recommendations on gee, folks, can't we all get along? Because honestly, that's what it comes down to in the end.
Yeah.
Board members have to get along to an extent. Even if you disagree with the person, the other people who are sitting on the board with you, you still have to get along with them. And understand that since it is representative government, if a majority of the board votes in a way that you absolutely disagree with, you don't have to like it, but you have to go along with it.
Yes.
That's how decisions are made in associations. And you don't have the authority to then go out and, pull out association documents and undermine what the board did, or God forbid, pull out confidential communications from the attorney or someone else and try to make your point. The decision may not always go your way, but the decision is still the decision, and that's the official act of the association.
Yep.
Okay. Yeah. Here's a good question. It relates directly to what Kara was just saying about pride. And we spend a great deal of time on violations. How do you get the homeowners to buy into respecting the appearance of the property?
Well, I would say this. It's going to fly in the face of what you know. Catch people doing things right. So try that on first. Catch people doing things right. When we're only busy catching people doing things wrong, this is sort of what happens, right? What I find is when we communicate and we talk widely about individual issues we're having and how to solve them, people will start following the rules and regulations because they too have pride in what's going on in the community. So catch people doing things right. That's my recommendation.
But
I know.
But if you catch them doing it wrong, be consistent and be efficient. If you have had the attorney send out or sent out your own violation letters for people who put, for example, container gardens, if you don't allow container gardens, then if someone else has a container garden, treat them the exact same way. Consistency is important.
Yes, 100%.
And the board can determine. My recommendation for finding policies, for example, boards come to us for finding and rule and regulation enforcement policies. I'm not personally a big fan on a fixed fine. Every violation, first violation is $100. Every second violation is $150. My recommendation is fines to be imposed between $25 and $500. Allow the board to make a reasonable decision about how serious a violation this is. I use an example. Sorry, I'm going to use it anyway. Again, if you have a rule and regulation that requires people to clean up after their dogs, if you have a guy who just got a brand new puppy and he's taking it out for his first walk in the association and he forgot to bring his baggies with him, are you going to treat that person the same as the guy with the Rottweiler who walks his dog on someone else's lawn and let the dog relieve itself on his lawn without cleaning up every day? I think the answer is no. If your rules and regs say this violation is this fine, then you take away that element of discretion and, in my view, fairness from what the board is doing in addressing those problems.
And one thing I want to add is I have often found at board meetings that we have the insurance contract. It's $100,000 contract, and we have a 10-minute discussion, and it gets approved. And then we spend the next 40 minutes talking about one $25 late charge. So here's what I say to my boards. Guys, you always fall on the same side of this issue. You don't want them. You do want them. You just look at the circumstances and vote, because those little things are just not what we need to be focusing on.
Good point. That's an excellent point, Kara. Yeah, I think that resonates with a lot of people.
I'm sure it does.
Yeah. Does confidentiality extend after the homeowner is no longer a board member?
Yes. Information that is the information of the association, the privilege to release it is held by the board. And if you're no longer on the board, you no longer have you don't have any say in the authority of whether to release it. If you take information, for example, if you grab a copy of an attorney, and I'm using a personal example, if you grab a copy of an attorney opinion letter on an issue that maybe you were one of the minority on the decision on, and you take a copy of that letter and you're no longer on the board, and you want to say, well, look at what the board was doing on this. You've just violated your fiduciary obligation, and that obligation extends past your time on the board. Confidential information is confidential information, and only the board has the authority to waive that confidentiality without the potential of consequences.
Hear, hear.
Yeah, and we were talking about rules and regs, and early on, in some of the questions, I was noticing that even though we were talking about board responsibility, boards are also concerned about homeowner responsibility. So how can they educate the homeowners when homeowners just say, well, I didn't know? And then there's a related question. There's two different ones, but the other question is it a law that all homeowners have copies of the governing documents, rules, and regs and sign off on them?
Sign off on them.
Yeah,
sign off on them is not a rule.
They receive them
There's no requirement. That works. That's for condominiums. It's under Section 22 or 22.1. And the way it works is a buyer of a unit in an association, until they become the owner of the unit, they have no rights with regard to the association. They're not members. So how it works is a buyer, a potential buyer, asks the seller, who is a member of the association, to obtain those documents from the association and hand them over. Attorneys who are doing their job and doing their due diligence are going to make sure those documents are obtained and turned over prior to the closing. If I'm an attorney for someone who's buying a unit in the association, I sure as heck want to know what those documents say before the paperwork is completed. But there isn't a requirement that they sign for them and acknowledge that they received them.
Okay, so that's more on the real estate side than on the condo side.
Yep.
Okay.
Yes and no. Here's the thing, you guys. Everyone is not going to do what we want them to do. Everyone's not going to read the documents. It's just the way it is. We need to not get upset about that. So I'm now in a learning and development role for corporate, right? And so I'm teaching managers. So when I see something going wrong and I think, you know what, I gotta make sure they understand this. That's what I do, right? So if you see the same thing happening over and over, then there's a place for education there. That's what I recommend. People are not going to read. Not all people are going to read the governing documents. And I'm sorry about that, but it's just true.
True enough. And oftentimes the instruments of an association will require that someone leasing out their unit make sure that their tenants have a copy of those governing documents and rules and regulations, and that they can make them sign for, because that's a little different,
right?
A little different issue.
Yep.
Okay. How best can a director exercise a vote of abstention? Maybe the question is, can a director just vote to abstain rather than yes or no?
Absolutely, yes, they can. They have the right to abstain from the vote, and I'm looking for. There's a provision in the Not-for-Profit Corporation Act, and I wish I could, and I will continue to look for it. But it basically says how you deal with that issue. If, for example, a board member disagrees with the majority, they can vote against, and submit a written notation for the file that they oppose the action the board took. Or they can abstain from voting and then submit, as I've noted, a notation subsequent to that to indicate I abstain from this. And one of the reasons why a board member might do that is so that if they believe that what the board majority is doing in some way is contrary to the fiduciary duty or some other duty of the association, and they don't want to have been seen as signing on to that. Mm-hmm. One way of doing that is making sure that a roll call vote is recorded in the minutes to say that directors A, B, and C voted for, but D and E voted against, and make sure their names are in there. Or if you're the individual director who votes against it and your association doesn't keep that roll call vote, to submit a written notation on that fact for the records after the fact.
Right. Yes, a board member can. Sorry. A board member can request a roll call vote, right? Because what happens there is that people can't hide behind the board. They actually have to say, here's what my vote is. And it's not to be used in a, gotcha way, but rather we want each individual, because it's such a controversial issue, we want everybody to be on the record.
Okay.
Some of you may have heard of the Boucher case, Boucher. It's a condominium case from Chicago, where the court came down fairly heavily on a board. All five, I think it was five board members were named in the original lawsuit that was brought against the association, but two were dismissed from the suit because they were able to demonstrate that they voted against the action that got the board in trouble.
So, nice.
Oh, very good. Okay. What is Illinois condo law? Let's see. I'm not sure how this is worded. What is Illinois condo law to percentage of homeowners needed for 3 boards of a master association to get rid of the existing master board who were not elected?
There's nothing under condominium law specifically. That's going to be an issue that breaks down to what your governing instruments say and what the instruments of the master association provide for. That's beyond the scope of what the Condo Act expressly mandates or sets particular terms for. So that you're going to have to look in the instruments for your individual association and the master association that is over it, along with others. And
right, and I find
consult with counsel on that.
I find master associations, the setup of master associations is you can find all arrays of how they're set up. So there's no way Jim and I could actually just say, here's the way it works. They're all different. So definitely that is one of the things you want to consult your governing documents on.
Yep, absolutely true.
Okay.
I'm still looking for that provision, but I haven't found it yet.
That's okay. What do you do about a board member who won't report a violation if it's their neighbor, but will report people on other streets?
You know what? Jim, why don't you take this one?
Thanks. My issue would be if I were part of the board, I would want to have a conversation with that director about the fiduciary duty. You owe a duty to all members of the association, and part of that duty is to enforce the association, act consistent with, but also to enforce where enforcement is required, those instruments. And if you are letting your friends and neighbors off without notifying the board about their conduct, but going after people who either you don't know or you don't like, you're not acting in a way that's a representative of the entirety of the association. You're picking sides. And I would recommend that that's not the way that a board member should act. And the other members of the board, when made aware of that conduct, should raise it and address it.
100%. The bottom line is you want uniform enforcement. From a practical point of view, if that board member is picking and choosing what violations exist, either you need to supplement it with someone else, making sure that all of the things are actually covered, or quite frankly, hey, we'll go and look and independently verify at whatever you're writing up, because you're not writing everyone up, and we are not going to just take your word for it. That's my recommendation in a practical sense.
And one more point. The governing documents, the declaration and bylaws are imposed or interpreted by courts and given a whole lot of deference, because the only way to change them is by a vote of the membership. It's not just a board discretion issue, but rules and regulations that are almost universally something that the board can adopt and that the board can enforce are given a lot less deference by courts. And if, for example, a board, whether by the action of one board member or a group of board members, is letting violations go, on one hand, they may find that their ability to enforce those same provisions against someone else has been waived if challenged. So it's an issue that goes right to the power and authority of the board as a whole, which is why no individual board member should be acting in a way that is contrary to the best interests of the association and all of its members.
Okay.
Yep. That's what the fiduciary duty is.
Here's a related question. If a board member has been harassed by other board members or another board member, is that board member allowed to follow up with the association attorney to stop the harassment?
Okay. Following up with the association, Kara's laughing at me. Following up with the association attorney, remember that consultation by the association with the attorney incurs expenses for the association that are common expenses. And the incurring of common expenses is a matter for the board to decide. So typically, that kind of issue would have to come before the board first, and the board would have to vote to authorize that the attorney be consulted on it and their opinion be obtained on how to deal with that situation. That's the textbook answer. Go ahead, Kara.
No. So we're talking about fiduciary duty. So if a board member comes to a board meeting and says, I am being harassed by X, Y, and Z, and it goes against the norms for the group, which I would highly recommend that they do, then that board member is in breach of their fiduciary duty. And I would, as a board, consult the attorney and management to find the best way to deal with this. You can't just let it go because you don't want to deal with it. You can't just let it go.
I totally agree with Kara. That's the boots on the ground perspective. My perspective is like, well, is this authorized contact and an authorized expense? But from the perspective of the association board, they really have to deal with it.
Right.
Okay. We only have about 9 minutes. I have 2 more questions here. If the board changes the declaration, shouldn't the homeowners receive a copy?
Yep. It depends. It kind of depends on what kind of association you have, but the rules typically require, the Condo Act typically requires that a copy of that amendments to the governing instruments are effective upon being adopted, recorded, and a copy being delivered to all the members of the association. Okay. It doesn't specify that it be in writing on paper, but at the very least, they have to be transmitted out to members of the association.
Okay. So would it be sufficient for them to post it on a website that isn't proactive, but more reactive from we posted it on the website?
I would send it out to the owners. Think about it. We're sitting here talking about people that don't read their governing documents, and then we're going to have a conversation about not getting them their governing documents. You sort of can't have it both ways. So I believe that you need to proactively provide information to the owners.
Right. Yeah. I do too. I think it needs to be distributed, and that brings me to a pet issue that I have with associations. There are provisions in the Condo Act and the Common Community Association Act about boards and associations' ability to use, for example, means of technology for its communications and its official conduct of business. But they require, in my view, that the board officially adopt policy, including adopting and creating a consent form that gets sent out to all members of the association. And then for those members of the association who give their consent to conduct business, for example, by email, then their business is conducted by email. They can get information, including governing documents and amendments, by email. But for those who don't consent, the board remains obligated to send them their hard copies of meeting notices, changes to governing documents, rules and regulations, all of that. So many times I see boards, and quite frankly, some other attorneys recommending to associations that all they have to do is just send things out by email. Or adopt a rule that says we can send it out by email and don't get consents to do it. In my view, the Condominium Property Act and the Common Interest Community Association Act and the sections that put those provisions in place specify otherwise. And there's a little more that you need to do. But once you've gone to the trouble of doing it, the world of electronic communications is opened up and everything gets easier.
Right. I share that view.
Okay, very good. Okay, this could be our last question. Now, it's not exactly related to fiduciary duty, but I think that it's such an important question. I'm going to throw it out there and let you answer it because a lot of people don't understand this. Would you explain the difference between a limited common element and a common element?
The common elements, and it depends to an extent on whether you're a condominium or a non-condo. In a condominium, remember that what you bought is a box of air. That box of air sits within a building. The support structure that holds up your box of air is all common elements. So your perimeter walls are the border of your box of air. Interior walls, that's different. You may be responsible for those. But outside that box of air, the building is common elements. Now, there are parts of the common elements that are dedicated to only your use. For example, nobody, unless they're Spider-Man, can get to your balcony. So that's an area within your exclusive use. That's a limited common element. It's usually defined in your instruments. It's typically reflected on the plat, but it is a portion of what is the common elements that is dedicated to your own use. And the rules and regulations or the provisions in the governing instruments about maintenance and responsibility for those is a little different for the portions of the building that hold it up, the regular common elements.
Right.
And for non-condo HOAs, it's a similar situation. They would be portions of what would otherwise be common area that are designated to your individual use. perhaps a fenced patio or a backyard or something like that. But that's a creature of the documents.
Right. So the way I look at it, just very simply, is the common elements. The limited common elements are just simply a subset of the common elements, and they are for the exclusive use of an individual unit, and that's really the definition. I will say this. There are a lot of associations that their governing documents are silent about how to maintain those limited common elements. So you need to make sure as a community that you address those things and that you come to a consensus about maintenance responsibilities.
Well, thank you very much. I want to thank both of our panelists for sharing your expertise and your knowledge. And you both, I think, have been in the industry so long that you have a really good way of explaining this so that even us homeowners and people that don't participate in this business can understand. I love your explanation of a box of air or, the subset. That really helps people, I think, understand. So thank you very much for giving us a couple hours of your day today and answering so many questions for our homeowner members.
Yeah, thank you for having us. I am speaking for you, Jim.
I appreciate it, because I was going to thank CII for giving us the opportunity to address so many members of the Common Interest Community Association and Condo community.
Yep.
Okay. Thank you so much. Bye-bye.
Bye, guys.